Okay, good day to you all. Welcome to another session of our group of Friends of Multilateralism. This is a session a little bit peculiar in the sense that with the incoming Ministerial Conference 13, we are switching a little bit of focus to the way forward towards MC13 and potential outcomes, so on and so forth. So we are doing a lot of internal briefings to prepare ourselves for that. But there are some issues we cannot wait. Some issues are too big for us to just put aside, such as this one on trade and national security, because this issue has been on the table of the WTO and beyond the WTO for years. And its impact is more than just bilateral among few countries. It's affecting not only international relationship, global supply chain, and also the collaboration in various international organizations, particularly in the WTO. So we think that it's time we should pick this up and discuss it. Of course, you have seen Alan's book on that, and with that he has also put forward one paper on that, and we also got a paper from Bernard and Petros and so on and so forth. But I won't take long. I just want to emphasize that this may not be part of the MC13 outcome, but this definitely should be part of the MC13 discussions. I hope the ministers will have a sensible discussion on that. And with that, I will give floor to Patrick, who has kindly agreed to moderate, and also to the panelists for their participation. Over to you, Patrick. Thank you very much.
Thank you very much, Lou, and greetings to everybody. Just a few introductory words, if I may. You know, this question of national security has become increasingly come to the fore and has become increasingly contentious. It's been the subject of several disputes. Some of them have played softly. Others have been a little more definitive. I think when national security really started to come to the fore was when President Trump used this as a reason for putting import restrictions on steel and aluminium, and a lot of members thought that this, in Bob Hudek's favorite words, didn't pass the laugh test as a national security issue, and there were a lot of responses that of questionable WTO consistency as well. So it's all added to the mix of the breakdown of WTO disciplines. In addition, I think it's also fair to say that because of ICT and technology, it's become a lot easier to worry about national security beyond what crosses the border and whether there's a war and whether somebody's embargoing your trade. And so that also adds to the tension. I think several of the panelists have written about different ways of addressing this and different ways of solving it. So I think we're lucky to have the panelists. I don't need to introduce them because they're all well known, and anyway, their short bios are on the flyer for the meeting. So the only thing I urge you, please, is because there are quite a few of you, and because there's quite a large audience, and we might reasonably anticipate discussion, if you could try and stick to your 10 minutes, your 10-minute allotments. Okay, with that, let me invite Alan to take the floor. Alan, it's yours.
Thank you very much, Patrick, and it's a pleasure to be with all of you today. This is a very interesting subject. The more one delves into it, the more interesting it becomes. If any of us had been drafting Article 21 way back when, actually its predecessor at the ITO, I think we could have come up with this. Sounds very sensible. And it worked for quite a while. Why did it work? It was not invoked to protect domestic industry as a substitute for other trade measures, not even by the United States. Its use was not generally adjudicated. There just wasn't much in the way of dispute settlement applied to this area. And because of these two conditions, it was not previously a reason for the United States to resist binding dispute settlement. But I think solving this issue, the use of Article 21, justiciability of national security, is now an impediment to finding an end to the impasse on the putting together, again, binding dispute settlement of the WTO, which I favor. As Patrick has said, what changed? Trump. And actually, if he comes back, there's more change to come. But steel and aluminum tariffs. But it was key not to litigate what was national security. Sort of an easier case, Argentina, the EU trade measures against Argentina during the Falklands War. You just look at the provision of Article 21, you just apply it, and it wasn't very controversial to my knowledge. What was controversial was Helms-Burton, where sanctions were applied by the United States to European companies in the course of trying to put sanctions on Cuba. How was that resolved? Two mature major trading entities, the EU and the US, worked it out, and the case was withdrawn. What's really troubling to me is the Russia goods in transit case, Russia-Ukraine. The panel seemed to find that as long as there was a war, an invasion of Ukraine, then, you meet the criteria. This is very weird to me, unintended consequence, that if as long as you actually throw a missile at your opponent, you then qualify under Article 21, where you wouldn't otherwise. That's a bizarre result. It doesn't demonstrate that the original thinking was wrong. It does demonstrate to me that adjudication doesn't really work. What's in a country's national security or essential security interest? How does a panel get into that? The Russians certainly believed that what they were doing in that case was a part of its essential security interest. What if the case involved Moldova and the Russians cut off fruit and vegetable exports because it's concerned that Moldova might, this is all hypothetical, Moldova might join the EU, it might ultimately join NATO. Russia doesn't want a NATO member, additional NATO member on its border. Is that part of its essential security interest? And what makes it useful to have three trade experts decide what's in Russia's essential security interest? Lots of issues with respect to China. China was upset over THAAD missiles being deployed in South Korea. Was that part of their essential security interest? Presumably. Now, they didn't take a measure, but tourism dried up from China in South Korea at the time. Let's assume it was a measure for these purposes of discussion. Is it now justified? Because there's no war. Or is there a war? Is there a Cold War or not? In steel and aluminum, the interesting thing historically to me is in 2002, 35 American steel companies were in bankruptcy and one was in dissolution. The industry was going down. Let's assume that part of the problem was global excess capacity. What's in the national security interest of the United States in 2002 if its steel industry is severely eroded? The purpose of the Trump measures, which no trade expert outside the Trump administration thought was valid, but the purpose was to keep capacity utilization at 80%. Would a panel say, well, we don't think 80% was correct, we think 70% capacity utilization would have sufficient, or 50%, or 20%? How can a panel substitute its judgment on essential security interests and determine for a member of the WTO what those interests are? What's the capacity utilization level that's correct? And is there a war or not? There's certainly a rivalry between the two largest trading countries now. Is that a war? No. Okay, perhaps not. But how does it help to have this litigated? One last hypothetical, which is not a hypothetical exactly. U.S. put on an import surcharge for balance of payments reasons in 1971. It was on the gold standard. It was running out of gold. It was fighting a war in a Cold War with respect to the Soviet Union. It was fighting a hot war in Vietnam, and the dollar was going down in terms of its being defended. The U.S. was in a currency crisis. The U.S. put on an import surcharge. It did not use Article 21. It used Article 12, and it said this is a balance of payments problem. Regrettably for the U.S., surcharges were not allowed under Article 12 at the time. Only quantitative restrictions. So the U.S. defense was, we could have done worse. We could have disrupted things more with quantitative restrictions. But if this had gone to a panel under Article 21, would it have been acceptable? Where I come out in all of this is that national security is essential security is non-justiciable. I agree with the U.S. actually on this point. I agree with Russia on this point. However, there has to be a cost imposed for harming the trade of others, regardless of whether there's a war or not a war. And in the instance of steel and aluminum, that cost was exacted by most of the major trading partners of the U.S., starting with the EU. So by calling it a safeguard measure. So what I would do is have this be sort of Article 28, rebalancing of concessions. That's where I come out. And I probably wouldn't have written the paper if I'd had the very good paper by Petros and Bernard and colleague, because they actually have some very good ideas about how to approach this as well. But one of them is get this out of litigation in terms of finding of whether essential security exists or doesn't exist. This is a very complicated world now we live in, and our essential security interests, any of us, any country, are really very hard to probe, with the exception of Swedish footwear. I'll pass this on. Thank you very much.
Thank you, Alan. I'm sure you know that you're in a bit of a minority thinking that Article 21 is not justiciable amongst the members, but there's nothing wrong with being in a minority. But that is, it seems to me, at the core of what has to be sorted out. Anyway, now, Bernard, would you like to take the floor?
Yeah, thanks. Okay, so I'm sharing the floor with Petros. You can hear me?
Yeah, if you're sharing the floor with Petros, perhaps we should let Nadia go first.
Fine
if you're going to play off each other, because Nadia is a special guest who's just finished writing a PhD on this topic. I think Petros had something to do with her thesis, and we kind of agreed that I thought she was going to speak just before Petros, but actually on reflection, it's probably better if she goes now. So if you're okay with that, Bernard, let's ask Nadia to say a few words. Nadia Garcia.
Thank you. I'm going to share a presentation just to sort of follow up the explanation that Professor Wolf was sharing with us. Can you see it? Can you see the presentation? Okay.
Yeah, we can see it. We can see it. Yeah.
Thank you. So what I'm going to do is I'm going to be focusing on the reasoning of the panel in Russia Traffic in Transit, which presented the first opportunity for a WTO panel to evaluate the justiciability of that Article 21. And to date, it is the only panel report that has been adopted that has made a ruling or an interpretation on security provisions at the WTO. As you are all familiar with GATT Article 21 security exceptions, the provisions that are included in this clause have been ruled by a panel as partially self-judging and partially not self-judging. This is that the elements that the article has have two different treatments. On the one hand, the chapeau of Article 21B has been considered by the panel to be subjective. This means that it falls within the members' discretion to determine what the actions are necessary to protect their essential security interests. However, the panel thought that this freedom for the members to determine the necessity of the actions and the security interests that are needed to be protected from threat are not without any limits. This is that the members need to interpret and apply this chapeau in a good faith, which means that members are not free to elevate any interest to the category of an essential security interest, and that also members need to explain the necessity of the measures taken in a sufficient manner that meets a minimum requirement of plausibility. On the other hand, the panel considered that subparagraphs 1 to 3 are elements that are subject to an objective determination by a panel. This means that a panel may take a look at whether there is a war or whether there is an emergency in international relations and determine if the actions taken were followed by the start of this war or emergency in international relations. This means that the chronological concurrence of the circumstances and the actions taken have to pass a test of validity followed by an objective review of the panel. So what we can see with this reasoning of the panel is that the panel tried to split the child to arrive at a Solomonic decision and to provide part of the provision that is going to be within the members' discretion and part of the provision that is going to be within the review of a panel. What they tried to do was to balance and try to reach a way to prevent members from abusing these provisions and from imposing measures that were just a disguise of protectionist measures for other reasons. So what is really interesting about the Russia Traffic in Transit report is that the panel stated that political or economic differences between members are not sufficient of themselves to constitute an emergency in international relations, unless they give rise to defense and military interests or the maintenance of law and public order interest. So as Professor Wolf was saying, this is counterintuitive because it seems that if the emergency or the situation is escalated, then the member will have a better justification to apply the measures to protect the set essential security interest. What we have seen right now in the arguments of the United States in the steel and aluminum disputes or the Hong Kong dispute with Hong Kong is that there's a contradiction because the tensions have not reached such a level of stress. Then the panel has not found, for instance, in the case of Hong Kong, has not found that the requirement that there was an emergency in international relations was fulfilled in that case. So in conclusion, the panel in Russia Traffic in Transit considered that Russia had not violated the agreement because the actions that it took fell within the scope of Article 21b3 and the measures were covered. And it's worth noting that the complainant, Ukraine, did not appeal this dispute, which underscored the impact of the panel's findings. And additionally, it also allowed this panel, this report to be the only adopted report. And since then, subsequent panels have to a large extent followed the roadmap established by this panel, which is something that Professor Medrovis is going to elaborate on. Thank you.
Thank you very much for that, Nadia. Bernard, are you and Petros going to interact together, or are you going to go sequentially?
We're going to go sequentially. I want to say a little bit about the bigger picture, and then Petros is going to come back to national security.
Okay.
Okay, so let me share my screen. Okay, so what I'm going to be speaking to is work that Petros and Doug Nelson and myself have been doing, which really focuses on a subset of what today's discussion is mostly about, national security. And essentially we argue in that ebook, which is it's published by CEPR, it's available for you for download. But essentially the starting point is that we're seeing an increasing focus on what we call non-economic objectives being pursued by governments through a trade instrument. And national security can be regarded as the non-economic objective par excellence, in a sense that that's what it's all about. But there are many more types of non-economic objectives being pursued. And what we argue in the book, that's really a big challenge for multilateral trade cooperation, right? And so one of those challenges, how do you disentangle what governments are trying to do if we start thinking about how can we impose disciplines on what they do, which are not only about internalizing spillovers, but would also help those countries actually achieve the objectives they have. Right now, you're all very familiar with Simon Evenet's work with the Global Trade Alert. And there have been people now working to kind of go through that database and ask the question, what are governments actually saying they want to do? Right, so as you all know, I think there are over 50,000 measures now in the Global Trade Alert being taken by the G20 countries, which illustrates something about their commitment not to do that in 2009, which of course Simon has been elaborating on since 2009. But what this graph shows you is one effort by a group of researchers to say, okay, we're going to use natural language processing techniques, text analysis, to go through all of the language which is in these regulations which underlie the Global Trade Alert and say, okay, so what are governments actually saying they want to do? And what you see here is that in recent years, something around 50% of all interventions are essentially industrial policy types of interventions. And you see that dropping off a cliff in 2020 as COVID hits, and there's much more intervention by governments to deal with that crisis, right? So that's clearly not industrial policy. But I think that's a stylized fact that we keep in our heads, and I think it's important for all of us to think about this. So there's a lot of traditional, what I would call old-fashioned industrial policy being pursued, but very frequently under the heading of trying to achieve a non-economic objective. And the environment is example number one in this regard. Right, so if you look at notifications to the WTO of quantitative restrictions, you see an increasing incidence of the words essential interests in terms of what governments, what they're motivating, what is motivating the use of these quantitative restrictions. And you can also see that a large part of that is not the EU, it's not the US, but it's other countries, right? So this is not something which is specific to the geopolitics that we observe at the moment. We're seeing this in many countries. They are clearly concerned with pursuing essential interests, however we want to define that. But this is just picking up those two words, right? So it's mentioned in the notification. Similarly, if you look at the Global Trade Alerts and you ask yourself, how frequently do we see specific words appearing as motivating a particular intervention among the set of non-economic objectives, right? So you take out the industrial policy stuff, which is clearly related to competitiveness. You see that the word dual is the number one word that gets mentioned in these measures, right? So that pertains to dual use in many cases. Security comes next. Number 3 is communications. A lot of that has to do with 5G, with network infrastructure, and again, that is related, therefore, to economic, if not national security. So I think the challenge that we elaborate on in the book is, okay, so how do you deal with this? And what we argue is that one way of starting, and this is not just for the WTO, this is also at the national level, think about and get governments to actually articulate, what are we trying to do? What is the objective? What's the problem? Then identify, okay, what are the policy instruments we have to deal with that problem? And among that set of potentially available, feasible instruments, choose the one that is actually the best, right? Now that's called the theory of economic policy. In economics, this was developed in the 1950s, 60s by people like Max Gordon and Jagdish Bhagwati, Srinivasan. And what we argue is that that is an approach which is actually useful to start thinking about what we're observing. And the problem with that theory is that that theory is mostly designed to deal with economic distortions, right? And if you think about what the GATT was trying to do, one way of thinking about all of the disciplines we have there is essentially ways of dealing with the spillover effects of what governments are doing that are really pursuing economic objectives. The challenge is, how do you also do that for the non-economic objective bits? Because we have well-developed economic theory that looks at basically market failures as a rationale for intervention, but that theory takes non-economic objectives as given. So they either completely ignore them, or they say, insofar as they enter into the decision-making function of a government, we take it as a constraint, right? So the constraint is the government wants to have at least 10% of production of good X being produced domestically, and then we figure out how can we do that most efficiently. The question is not how can we effectively and efficiently achieve a particular non-economic objective. So one way of dealing with that, at least analytically, is to consider non-economic objectives as part of the things that governments are trying to achieve, right? So put it into the objective function. Now, this is very hard in practice because quite often the non-economic objectives that governments are pursuing, whether it's national security, economic security, climate, competition, are not very clearly defined. But at least what we argue in the book is that this theory of policy approach is a way of thinking about the spillovers that are created by interventions, and by also about thinking about how do you achieve those objectives more efficiently. Right now, that has implications for the efforts to update and reform the WTO. One dimension of this is if you actually do this a bit more seriously than we seem to be doing today, where it's very much about essentially giving governments the right to intervene and other governments then to take action if that affects them, is to actually think about the fact that it's not just about reducing the spillovers of national policies, but that cooperation can actually enhance the ability to achieve non-economic objectives, right? And one, I think, clear stylized fact here is that if you look at across all the motivations we find in the Global Trade Alert for intervention, and you ask, how much commonality is there across countries? It's quite large, right? So many governments are pursuing the same objectives, right? So that suggests that there should be scope to actually do more if you can actually agree on what is a common or a shared objective, to start thinking about how do we pursue that objective in a way that both reduces spillovers and enhances the effectiveness of actually achieving that objective. And the problem here, we argue in the book, is that the WTO doesn't really take that approach. The WTO is very much focusing on the spillover effects of national policies, the competitive effects on industries. It's not really thinking collectively about how can we jointly achieve shared non-economic objectives. And there even hasn't been much of a discussion about where do we actually agree that we do have shared non-economic objectives. And of course, we have lots of international conventions in different areas that many countries have signed on to. Think about ILO conventions. But there's also many where we don't have universal membership. And that's beginning to change. It's reflected this change in the agreement on fishery subsidies. but it's pretty nascent. And what we argue in the book is that there really has to be thinking about, in the context of ongoing discussions about WTO reform, how can you do more to incentivize and support a process which is consistent with this theory of economic policy principles, to actually define what is a government trying to achieve, what's the effectiveness of chosen instruments, how large are the spillovers associated with that action, recognizing that spillovers need not be negative. And quite frequently, when we're talking about non-economic objectives, they might be positive. Insofar as they're positive, that then implies that we shouldn't be countervailing those measures, right? That will be one implication of that. And I think the more that process identifies shared objectives, the more likely it is that you can start thinking about plurilateral cooperation to actually pursue that. And again, not everybody's going to share the same objectives. So I think plurilateral cooperation is here to stay. And again, that's a bit of a different topic, but again, that's one of the implications. And what we argue in the book, and a large part of the book is actually about national security, which is how do you apply these types of principles and concepts to the national security issue. So I'll leave it to Petros from here on. You want me to start showing, Petros?
Yeah, but I cannot do anything. You have to move the slide, Bernard.
Thank you, Bernard. Now, Petros.
Bernard, can you put back the slides?
Yeah, just tell me when to switch.
Yeah, but they're not there. They disappear.
Sorry. I need to share again. I thought you wanted to do it on your side.
No.
Okay.
Okay, next one.
Let me maximize. Voila.
Okay, so I'll speak just about the national security part of the book. In a nutshell, what we suggest is we believe that there should be some scrutiny for the reasons I'll explain briefly, but we're not big fans of justiciability of national security for two main reasons, 2.5. One is the law is totally outdated and we don't want adjudicators, panelists, to update the law. This should be the competence of the membership and not of the agents. Second, because the process as it is does not inspire confidence for a number of reasons here. And finally, because this is not a good moment to discuss sensitive cases in the WTO when trust is not exactly on its highest within the membership. Next one, Bernard. Now, actually, why scrutiny? We have a long discussion in the book. The main point is that during the GATT years, this is an empirical point. Of course, there is some discussion in the beginning, some theoretical discussion. The GATT was a relational contract in the beginning, 23 homogeneous players and so on. But when we look into the practice 97 to 1994, we found a dozen of invocations of national security. And with the exception that Alan mentioned in the first, the Swedish shoes case, all of them seem very reasonable invocations. And not only this, the membership was prepared to discuss national security complaints before the GATT Council, and they were quite reluctant to adjudicate Article 21. Now, one explanation, of course, is that the enemies were outside the GATT house. The GATT coincides with the Cold War. But be it as it may, that was the spirit of the GATT. And things have changed. Now we have dozens, hundreds actually, of invocations. And if we leave it totally unscrutinized, we risk seeing many Swedish shoes cases. I mean, actually, we do see many Swedish shoes type of cases multiply, mushroom. Next slide, please. So this is just the lay of the land. I'll go through it in 1 second. We have 14 panel reports that were issued so far, which sounds unreal when you compare to the GATT legacy. There are hundreds of invocations, over 200 before the TBT committee, over 200 before the Committee on Market Access, and a few in other areas. And Article 21 is drafted with the world of 1946 in mind. I mean, we found this fantastic paper by political scientist / historian Spikeman, 1938, who was arguing, says, well, I mean, national security, but we have the reassuring presence of the Atlantic Ocean between us and the theater of war in Europe, so why do we care so much? Now, of course, technology has changed all of this. Next, Bernard. So this is the key of our argument, why we don't like panel scrutiny. First of all, because we have become a little bit worried with the attitude of panels. Panels understand their mandate, they confuse right and obligation in our view. They take their mandate as license to adjudicate. There was a discussion, I mean, a very brief discussion of the political question doctrine, which is an issue that has occupied the minds of the US Supreme Court for decades. I found at least 12 discussions before the European Court of Justice, hundreds of discussions in other fora. In the WTO, it was 1 paragraph, 1.5 in the Russia panel dispute, and dismissed summarily. There is not one single case of non-liquet after the GATT years. GATT panels, whenever they get an issue, right away they adjudicate, and here this is a very sensitive issue. But they adjudicate based on what? The incentive to supply information are missing. I mean, one question we're asking with Bernard was, when we read Article 21 carefully and then we checked the history of Article 21A, Article 21A says black on white, nobody can oblige anyone to supply information if this someone thinks that the supply of information goes against its national security interests. So what if each and every respondent says, I'm sorry, I'm giving you no information about will they draw inferences on national security? How on earth will they adjudicate these cases without information? And now, it's not irrational that they don't want us to supply information. It's quite rational in our view, because confidentiality, I mean, we have big question marks concerning protection of confidentiality before WTO panel cases, panel disputes. The apex of confidentiality is the treatment of confidential information in the Airbus-Boeing case, where you had a room in the WTO. Thank God there is a book written about it by 2 political scientists from my school in New York at SIPA, and they spend a lot of time interviewing, to a large extent, the US delegation, and the US delegation essentially told them there was a room. In the room there was a computer. In the computer they had uploaded information concerning Airbus and Boeing subsidies. So those participating in the dispute, they could go, but they could not download information. Seriously? I mean, can you imagine anyone wanting to upload intelligence in a computer in a room in the WTO? I mean, this is unheard of. Then the standard of review of panels. We have big problems with the standard of review that panels have employed. I mean, Dr. Garcia explained how it worked in Russia, but quite frankly, I have found at least, I don't remember how many papers and how many books, starting from Kissinger's almost mythical treatment of this issue in the 50s, where countries essentially, for whatever reason, for good reasons, they bluff. I mean, why on earth should they reveal the information or intelligence? Now, the fact that there is no war or warlike or superficially warlike information should not lead panels to conclude there is no national security issue. Think of Stuxnet. Nobody had any idea about Stuxnet when it happened, but US and Israel had information about Iran enriching uranium in Tehran. So what you want them to do? Wait until a war erupts before they can stop the enrichment of uranium? I mean, if this case had gone to a panel, if they were all WTO members, applying the Russia standard of review, the panel would have said, I don't see a war here, hence you cannot do those steps. Are we serious? I mean, then the identity of adjudicators. And in the book, we spend a lot of time discussing, there are a number of, not just the US CFIUS, which is our model authority, but a number of committees, national committees, authorities, blue ribbon committees, whatever, which discuss national security at home. And quite frankly, when we look at the properties of these people and we compare, if you do a very basic typecasting of GATT panelists, this leaves so much to be desired. I would never like to see 3 panelists, the way panelists are being chosen and the qualifications they have in Geneva to discuss my national security issues. Of course, there is the costliness of errors. It's one thing to make a mistake in anti-dumping or in subsidies. Maybe 2 people will have to pay the price. I'm not saying it's not important, don't misunderstand me. But if you get it wrong on national security, what do you expect? I mean, there are institutional externalities. Why should they take the WTO seriously if they cannot even adjudicate, they cannot understand what national security is? And that's probably why nobody implements. I mean, who on earth would accept that they were, if I lose my national security claim, that what they did was sham invocation? For all these reasons, we think this is not the kind of cases we want to see before a panel. Bernard, next. So this I'll say it in one sentence. Bernard already spoke about the last bullet point, what kind of questions you should be asking. In our view, what we need is a committee on national security, where confidentiality should be on steroids, experts should be invited, and the process, if you want to have some formality, the maximum we would accept would be something like specific trade concerns. By the way, this is a tool that works quite impressively. Over 95% of TBT and SPS STCs are not transformed into formal disputes. So this is how we would see, ideally, if you wish, resolution of national security related disputes, not before panels. I think the next one is the last slide, Bernard. Exactly. If you want to read more about this, our book is it's sold in Amazon. I think it's only 150 Swiss francs, but you can get it at a better price if you say you're a friend of FMG, and I'll stop here.
It's of course free.
Exactly. You can download it, can't you?
Yeah.
Okay. Well, thank you very much for that. We now have our fifth actually speaker, Shiping Liao. I invite you, Shiping, to take the floor.
Okay, thanks for having me here. And I will try to share my screen here. I just wonder whether it is visible for all of us. Is it okay?
Yeah.
Okay, thank you. And I will try to address 3 points here, but I will put much more emphasis on the last 2 points. And first, the first point here, I think I just try to skip to it because I think all of us are quite familiar with the information here, and just go through directly to the second part, examining the WTO national security. We are full aware of the various effects or the invoking national security exceptions to bring the negative factors to all the WTO members. But I think maybe it is time for us to try to introduce another perspective here, because let's presume the national security exception is not suitable to be decided before WTO panels or the other mechanisms. But what will happen next? Is the national security exception still a deadlock for the development of the WTO law or even the rules or mechanisms? So I just try to look it in a relative positive way. The first, I think, whether it is appropriate for us to discuss to bring the national security exception case to the WTO panels, it is still an opportunity to try to pull the whole track into the legislation track. Anyway, we at least we should try something. And the second point is that if we look into the so-called jurisprudence, I use the quotation here because we only have one case adopted by panel, even not adopted by the appellate body. So at least in the case DS 512, we are the panel tried to resolve what will happen during the wartime. And in the following case, the panel at least tried to make further explorations or the elaborations on what the specific meaning of the other treaty language of Article 21. So maybe it is in a gradual way to and more specifically to discuss the treaty language or the legal connotation of the Article 21. But a related question raised in my presentation is something related to the patrons have previously stated. If we look into the texture of the Article 21A, that is my question here, how to evaluate respondents refusing to respond to the questions raised by the compliant in the consultation. It is not a fake question. I think maybe it had already happened in Geneva. Because if you want to the respondent to offer more and more information during the consultation, what the respondent can do, the only things they can do is try to tell the compliant that it is the information related to the national security or related to the to my essential security interest, and then they will decline to provide something. So the whole process will be actually blocked, even in the consultation phrase, let alone the next phrase, such as panel, as Petros has already discussed. There exists no relevant facts leaving to the panel to discuss, which make the rulings we are out of the origin. And the third point here is that is it possible for us to try to incorporate something which has already held by the panel report under the Article 21 into the potential drafting of the regional or bilateral trade agreements relating to the wording or the language of the national security exception? Since when we took the regional trade agreement, for example, they often involved different countries or members with maybe the similar cultures, similar economic, more closer economic relationship, which will facilitate them to agree more consensus on how to invoke national security in the so-called regional trade agreement. So anyway, maybe it will shed some light on the future or the future development of the Article 21 in the next decades. And my last point is that the two advices or two opinions about the so-called saving up through national security. The first is maybe we still need more and more cases invoking national security. I know it's maybe it is not the right forum for the panel or other mechanism within the WTO to educate the cases like this, but more and more cases will provide more and diversified facts when we try to make the full comprehension of the context of the Article 21. And the second option or the second opinion is that I think maybe we can choose to wait and see what will happen next. Because when we look into the state practice in the contemporary rules of international law or even in the international relations, it is the major trade partner who will try to do something to each other and at the same time invoking national security. Maybe the US, the European Union, or even the China will try to do something inconsistent with its obligations and the WTO agreements prima facie, and then try to invoke national security here to invade something. But if the practice goes more and more, we will find that the major trade partner will damage each other to a certain degree that they may have they may share the same need or create some rooms for demand for the common limitations on the invoking national security. So I think at present time, I think it's time for us to wait and see, especially some irregular trade practice, both from the Washington D.C. or from Beijing. And the last point here is I just quoted from the Chinese internet, which is the decision by the Cyberspace Administration of China in this May on the declination of the National Security Internet Review to American well-known corporations, Micron. And the outcome here is quite negative. But if we look into the decision itself, it is the original one. So the decision itself has only 3 or 4 sentences. It's quite concise. And if we look into the last sentences, we may find it that the characters I put in the dark black. The Chinese domestic operators are not allowed to purchase blah 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 according to Chinese cyber security law and other laws and regulations. If we put the decision here into the WTO limitations, we may find that what is the specific meanings of other laws and regulations, they are not listed here. It seems to me that it is a quite obvious violation of transparency or other requirements of a good faith or the which has already existed in within the jurisprudence of Article 21. So the example here shows sometimes even the Chinese government may carry on some trade measures, which is obviously inconsistent with the WTO obligations here. So here follows certainly will be the U.S. corporations resistance or the further further protest again from the Washington D.C. So as the 2 of the most important trade participation in the world, I think maybe it is still leave to the big countries or so-called superpowers to fight with each other. Here they have finally realized, oh, we should need some rules here. So I think that is the whole reason for me for the advice of let's wait and see. Okay, I think it's time. My time is up. Thank you.
Thank you very much, Xiping. Can we have the screen back? Can we have the screen back? Thanks. Well, this has been a discussion full of lots of ideas. And we have a little over half an hour for questions. Maybe I can just start with one that I'm interested in asking Bernard and Petros. Your vote of no confidence in the dispute settlement system as it stands, right? And therefore looking for a different mechanism for cooperation around national treatment. Would that apply to all the NEOs or just to national treatment?
You mean national security?
I'm so sorry. I keep saying treatment because it's embedded. I do mean national security, but you can still answer the question.
Yeah, so yes and no. So on the one hand, there's clearly going to be a lot of the measures that are being taken are effective, not about national security as such. And I think there you need to have an effective dispute settlement mechanism. along the lines of what we've had, right? But I think a precursor to that, we would argue, and Petros can disagree if he likes, is to have more in the way of this type of consultation and dialogue. It's just, okay, so what are we actually trying to achieve with particular instruments, right? And given that industrial policy is back, given that there's a lot of intervention to achieve what are clearly non-economic objectives, which again, the WTO is not particularly well geared to deal with, because all we have is Article 20 and 21, we could potentially take a lot of those potential disputes off the table by actually agreeing on, okay, I actually understand what you're trying to do, where you want to go, and let's think about how we can do that in a way which creates less in the way of spillovers and which might actually achieve this objective in a better way. And as Petros mentioned, the STC approach kind of goes a bit in that direction, where at least we're asking others, what are you trying to do? Why are you doing this? And at least that starts that type of discussion. But that said, we obviously need binding dispute settlement for efforts by governments to undercut their commitments along the lines of what we had in the original GATT. But I think it's important, at least in my mind, to not get too stuck on the national security as such, because I think that's too narrow an approach. And if you listen to what Trump was saying when he did steel, aluminum, there was a lot there about economic security, right? The EU now is really organizing a lot of what it's doing around this concept of economic security. And I think therefore it's incumbent both on the domestic political process to actually hold people's feet to the fire and say, what does that actually mean? And why are you doing this in this way? Because actually, it might very well be that you're undercutting our own economic security. Right now, in the purely narrow national security sense, that's much harder to do. Right, but I think for a lot of what governments are doing, I think it's perfectly feasible to do that.
Yeah. Now, why I asked that in part was because I was thinking about what's happening with subsidies. I mean, most of us, unless you happen to be a bit religious, buy into the idea that there are good subsidies as well as bad ones. And a lot of subsidy activity these days, amongst some countries anyway, is dedicated to trying to accelerate innovation that will help save the planet. But at the same time, it's all laced with preferences for national suppliers. And I mean, in that case, it's quite hard to see how you get around the latter part of that without going to some kind of formal dispute settlement. But certainly the idea that we should cooperate on the subsidies per se is an interesting one. But I just wonder whether you could keep out the protectionism at the same time.
No, I would say we need something in the middle. Before we say we're going to go to 3 panelists and start a dispute. What we need much more is your old crowd in economic research and analysis to actually say, okay, this is what you're doing. And this is based on historical experience, based on analysis of what you're actually doing. You are not going to achieve your objective. So therefore, it might very well be this is an exercise in protectionism. But I think we need to have much more of that factual analytical information on the table to make reasoned decisions and not just automatically say we're going to throw it to lawyers. I mean, that's, I'm letting my biases show here, but I think we need a lot more information.
You're attacking your co-author. Petros, do you want to say something? Unmute.
I would definitely take national security off the docket, and I'm all in favor of having specific trade concerns across the board. There is one category of cases where I started not even writing a paper, talking to a young Belgian economist, André Sapir, about, and we might end up with something in the near future. And this is the kind of cases that were discussed, John Weeks will remember very well, in Canada, the feed-in tariffs. There is no mechanism in the WTO for compensating for subsidies which have positive externalities. So whenever there is a positive external effect, there is nothing you can do in the WTO. And one question I think the WTO has to think about is, what am I going to do with this type of interventions? Is this the kind of cases you would like to see adjudicated? Or is this the kind of cases where we can find a consultation mechanism to take them off the docket and see what is the appropriate mechanism. And this is not, Canada was just feeding tariffs. This can go across the board on environment and climate change nowadays.
All right, let's open up the floor for questions. If you have a question for a specific panelist, please say so, and please indicate who's going to go. Andre wants to say something, I'm sure.
So Patrick,
No?
Patrick, are you going to keep track of the chat, or there's also some questions in the chat?
Oh, I'm sorry, I didn't even look at the chat. Well, do you want to answer any of the questions in the chat?
Well, there was one from Brad.
Was that a question or an assertion?
No, Brad is asking, can it be that governments are increasingly citing national security as a motivation for new measures out of convenience as opposed to a genuine rationale? And I think what we're picking up in the data, and there's more of that discussion in the book, is that most of the security is really around some notion of essential security. And a lot of that has to do with either sector-specific concerns around communications, for example, and not so much national security as such. I think in the overall scheme of things, and just what you see in the GTA, national security is still a very small share of the total. So I don't think it's the case that we're seeing a lot more spurious national security motivations. It's very much more this broader notion of security, including the European economic security concept.
Brad, are you satisfied with his response?
Well, maybe, but I do wonder whether, you know, in explaining their actions, governments are not sort of looking for ways that will buffer them from criticism, whether that be formal legal disputes in the WTO or whether it simply be from other people domestically. Right? I think it's very hard for somebody, whether the government's rationalization is economic security or national security, and I think most of the even most of our policy colleagues, not just the general community out there, tend to link those two very, very closely. But it's very hard then for somebody, if you consider yourself a patriot, to then question that, right? And I have to think that governments are exploiting them somehow, right? And I think they're probably already doing it, and they're going to continue to do it probably more and more. And if these things are not put under the light, then I think, you know, we're going to really be encouraging more and more of that. I do think what, you know, there are some very legitimate issues here, very important ones. And I think one thing that's changed over the years since this language in Article 21 was written is that, you know, the Cold War sort of idea. The Cold War existed, I guess, when the language was written, but I doubt whether people quite understood where that was going to be going in the decades that followed. But what's really different now, I think, is the whole tech linkage, right? And I think I love the idea that Petros and Bernard have about thinking about these things more, taking it away from, not necessarily excluding it from dispute settlement, I would say, although I think they would, but getting more analysis of it. It reminds me of what Bernard and others had written about in the context of subsidies and the notion of an epistemic community. I think that's very important here. Maybe you could bring together defense officials and others. But what is new, one thing that's new, certainly is the complexity of thinking about national security, say in the US-China context, and export controls and technological high-tech goods and these sorts of things. And that's certainly one example, it would seem to me, where more people sitting down around the table and more analysis and more economics, as Bernard was saying a few minutes ago, could really be important.
Okay. I see that Alan's asked for the floor.
Thank you. I applaud the direction in which Bernard and Petros are taking us. But STCs work perhaps for a reason where they work. namely standards are notified in draft, and the countries that are putting their standards on the table are doing so because they're getting reciprocity in part, and because they want the comments in part to head off problems. The notifications in the subsidies area, subsidies committee, doesn't work. Countries really don't want to hear from others about whether they're using their subsidies correctly, apparently, because they don't notify them. They don't want to discuss them particularly. So it's a good direction to go in, but it's one has to figure out how there are incentives to bring these matters into the system. And then there's the question Xipeng raised about transparency. Many of the national security measures, the problem may not be so much increasingly talking about essential security interests, but the absence of notifying them at all or transparency. Many of the measures are camouflaged by other things. It's sort of refreshing to see, although I don't know the validity of it, but it's refreshing to see the Chinese say that Micron is a cybersecurity problem, and at least calling out a reason for an action, whereas many times there are actions taken that have no justification given. Looking at just one last thing, the IRA, it seems to me a perfect example of where international cooperation would have made some sense in international discussion. The U.S. chose a flat-out WTO violation of favoring cars made in America, electric vehicles made in America. Was that the best way to obtain its objective? One would have had to have that discussed in draft optimally before it was enacted to have a full discussion of it, and maybe the U.S. try to mend its ways at the outset. Anyway, this is, I think, the direction that Petros and Bernard would take us, I think, is a very healthy one. The question is how to get from here to there.
Okay, we've got Lou, Andre, John, and Alejandro. Lou?
Yeah, thanks, Patrick. No, the discussion is very good, but my feeling is not that good. To recap a little bit, the thing is that the situation is bad.
Are you unwell? Are you unwell?
No. I'm just feeling unwell because of the dire situation here.
Ah, okay.
Yeah, so the situation is bad. The law is outdated, as Petros said, and we cannot leave panels to define. But we cannot let members to go ahead because of trustees not there. So we can neither do litigation nor legislation. So I agree with Alan saying that Bernard and Petros are pointing to the right direction to have a kind of process, a kind of specific committee on trade and national security, or broadly non-economic objectives. But given the same reason that trustee is not there, members are not agreeing to anything, can we agree in the near term or even midterm a kind of a committee on that? I doubt it. So for me, and also we mentioned that we need more research, more transparency, but the question is which division in the secretariat is in charge of this. Probably Victor could share a little bit about this. I don't recall any division is specifically following this and which could play a role in providing more researchers and more advice. So maybe can DG start something informal before we have a committee, a kind of informal process, even smaller group with house meeting or one item on the general council, informal term, whatever. But I do agree that we need a process to start to look at this seriously now, but we cannot wait too long for members to agree to a committee or anything else. Thank you.
Thanks. Andre?
Yeah, thank you. Great discussion. So I do share what Lou just said. I think that Bernard and Petros, I think they put their fingers on something very important, and I think they are right, obviously, in their criticism of WTO panels. So if you say, well, WTO panels are not up to the task in a number of instances on relatively mild issues, how can you trust them on such big issues as national security? Okay, that's a fair. I think that's a fair view, and so that suggests that one needs something else. And again, I think that is right. Then the question is, what is this something else? So I'm quite a bit in the camp of Lou, who said, okay, you're putting forward the idea of a committee, but is the committee, and let's say high-level committee, it doesn't have any of the defects, quote unquote, of some of the WTO panels. So you're solving that by putting a committee, high-standing committee and all of those nice characteristics. But still, would countries be willing to subject themselves for such matters to a committee? And when you see that some countries are not willing to subject themselves to an international court of justice, you start to be a bit worried. So yes, I think it's the right direction. I'm also not convinced that the committee is the solution. I will make one alternative suggestion, and a fairly obvious one in a sense, is to have members self-restraint, have not a new agreement on Article 21, but have a member state make a statement that binds them to self-restraint, and maybe have members discuss indeed, have some kind of a declaration both of self-restraint and of trying to limit nonetheless the scope. I mean, as a European, I'm obviously shocked by what happened in the steel and aluminum case. I mean, this is just not serious business, right? I mean, you can't sort of begin to see that the way it has been applied, that it links somehow to national security. It's clear that it was used, and we see it even up to today, it was used by a big country, because it's a different thing to have a small country using this as big country, but by one of the largest players, one of the three largest players at the WTO, as a way to enter into bilateral negotiations with countries. Sort of use a big stick and then say, I'm hitting you on the head with a big stick, and then I engage with you in bilateral discussion to remove the measures. No, I mean, it has left a very, very bad taste in my mouth, I must admit, on the use of national security. No, I don't need a committee. I mean, this is blatant, unacceptable. So those kind of situations, one should have self-restraint on that. Thank you.
John.
Well, thank you very much. Can you hear me?
Yep.
Let me say that I'll make 3 points. The first is that the WTO has always been a pragmatic organization, and the GATT before it. And I think one thing this discussion brings home, at least to me, is that at the current juncture, the WTO is in a rather precarious position. And I think it's important to recognize that this Article 21 issue and how it's handled really does have the power to severely disrupt what the organization does. So I somewhat reluctantly, because I've always been somebody who thought everything should be justiciable in the WTO, I think that there's a very strong case being made here that it would be damaging to the broader interests of international trade cooperation to make the issue of the application of Article 21 justiciable. It's already justiciable, but I just think in terms of how we handle this, that's something we have to take into consideration. I, however, think that you do need to have some reaction. And I think, you know, the reaction that Alan has suggested is one of allowing response in terms of a measured response, sort of a la Article 28 rebalancing of concessions. But I think there could be something that goes beyond that, and this discussion so far has touched on that, and that is to provide for some kind of discussion of the matter. This is sort of backing up one step from where the whole history of dispute settlement has been sort of moving from the model of the working party discussion of a trade problem to finding a binding ruling by a panel. And I think maybe here we need to think of how we back up a little bit on this particular aspect of dispute settlement and say that what we should have in this case is a requirement that a party invoking Article 21 would in some way in the WTO, and I don't want to get bogged down in which committee or working party or informal group by the DG, but there needs to be a situation created in which the party taking the Article 21 action would come and make an explanation of what they have done and why they have done it. And then there could be a discussion of that. The outcome, it would not be expected that the outcome of this discussion would be any kind of definitive ruling, but I'm mindful of what Alan said, that basically, and I may misquote him here slightly, but basically that there wasn't any American economist outside of the Trump administration who thought that the steel and aluminum measures were justified. And so I think this would be sort of a question of arranging for some kind of discussion that would show that the emperor had no clothes. And lastly, if I might say, I really do think this issue of cooperation on non-economic policy objectives that's raised in the paper by Bernard and Petros is a really very interesting area of activity. It obviously has implications for disputes for national security, but it also has a whole range of other implications for the international trading system, including subsidies, which was identified already in the discussion. But I must say, I think this is an area where we should, as going forward, think of whether we should be doing some more thinking about how this kind of discussion might be expanded and what relevance it would have for the future trade agenda. So thank you very much.
Yeah, you know, Pascal Lamy used to say that WTO legislates and litigates, but it's got a missing middle. It's a sort of similar idea, I think. But the problem is what you're going to actually do and to make that missing middle work as a meaningful basis for discussion. I mean, it presupposes a certain like-mindedness, which may not actually be there. But anyway, Alejandro.
Thanks, Patrick, and congratulations to all. Great discussion. A lot of ideas. One question and one comment. My question is really about the numbers, because when we talk about Article 21 cases, we're talking about cases in which a measure has been challenged and Article 21 has been offered as a defense. But since 1947 until now, looking over a wide spectrum of many, many conflicts among countries around the world, and derived from those conflicts many measures which have been adopted, I would submit that there have been many cases of trade restrictions applied in the context of war, context of other international tensions, which have not been brought to the attention of the members of the WTO because they have not been challenged. So actually the number of so-called national security could be much bigger if countries really had to, when applying a measure, come forward and justify the measure, or somehow explain why they are adopting the measure. And my second point, and I largely agree with a lot of what has been said, and I particularly John Weeks right now, a committee, a procedure, something could be a good idea. It could be a good idea to let steam off and to let a country come forward and say this measure is being applied. And the other party will say it's a national security, then no litigation, but there will be a chance where a committee or a group of experts, whatever, can point to the quality of the measure, the impact it will have, and so on and so forth, analyze all the economic impact, therefore, but not about the legitimacy of the issue, okay? In which case, you're just sensitizing the rest of the world to the effects, the impact of the measure, and that can be helpful. And let me, if memory doesn't fail me, I mean, the Swedish shoes or boot cases, I think, came forward because it was analysis of quantitative restrictions that had originally been balance of payments measures taken by many European countries, but after these were no longer the case, they remained in place, and countries had to come forward and say why they kept these quantitative restrictions. And then Sweden explained that this was a national security, and it was, shame. And well, and there were other cases too, if my memory doesn't fail me. There was something about horses in Switzerland, and maybe circus horses as well. So there are a lot of things that were done just in the context of questioning the quantitative restrictions that members were applying at that time. So name and shame helps to avoid imprudent use of Article 21 measures. Thank you.
Okay. Thanks, Alejandro. I can see Andre doesn't agree. Victor, we've got 7 minutes. So please be brief.
Thanks, Patrick. What Alejandro is describing is very similar to what existed in the BOP committee when one country invoked Article 18. It could be done, for example, in a special session of the General Council or in the Council for Trading Goods or something like that. But, I wonder whether people would agree to such a process, given the current political climate out there. One thing that has not been mentioned is, well, I guess now the genie is out of the box. But let's remember when the US started using national security and to what type of product. Steel and aluminum, which were usually the object of trade remedies. It's the law of physics. If you have a tension, you don't have a escape valve, it blows up. The appellate body closed all of the possibilities to use anti-dumping safeguards, countervailing measures. It blew up, and there you have it. Question: is it at all possible to go back and flexibilize the use of trade remedies? Or I think it's too late now. The genie is out of the box. What do you do now? And what we're discussing here are things that are meant to undo the mess created by the appellate body in basically closing all of the trade remedies escape valves. So I guess it's for us to cry and to find these other methods, which clearly are not going to solve the problem, but may alleviate the conscience of one or the other. Thank you.
Okay, thanks. I can let Evan have a shot go because he hasn't spoken yet, and then we go to Andre, and I don't see any other hands. Evan?
Thanks, Patrick. Be very quick. I certainly agree with what Petros and others have been suggesting, that trying to justicialize, if I've said that right, the question of what's a justified national security measure is not just a dead end street, but also dangerous. And it was something that the members, I remember looking into this years ago, recognized in the discussions back in 1947, and it was noted, I recall, I think it was by the Norwegians, somebody at that stage who had a lot to do with brokering the deal on the eventual GATT text, that this whole thing was a minefield, and people, we'd better just rely on people's good sense not to go dancing around in the minefield. Well, regrettably, we are now, as
Frozen
has just suggested, where, well, any formalized, any attempt to set up a more formal process is going to be very productive, not least because in the famous member-driven organization, I think there would be a lot of pushback from a lot of members. Maybe the best we can do at
You got a bad connection.
this stage is, so I blame Swisscom, but for the Director General or somebody to do some informal consultations or the like, talk about it in the margins of the General Council, in the margins of the next ministerial. Why not? I mean, and that's the sort of thing, you get them together, get a few people together, for a casual discussion in the margins. I would certainly start somewhere like that before trying to think about committees or the like, which I think would just be another dead end. Thank you.
Okay, thanks. Andre, you have 2 minutes, 1 minute.
One minute is enough. So I just wanted to say to Alejandro that, name and shame sounds very nice. In a nice group, it would work. But I can tell you that even inside the EU, it does not work. And in particular, the large countries do not want to submit themselves to that, even without sanction. So I think you have to recognize that one needs a system that applies not only to Sweden, but a system that applies to the US, to China, and to the EU and others, but also to those large countries. And I think one has to have that in mind. One has to be frank and say that there are large countries with huge externalities, and then there are smaller countries with much smaller externalities, and the system has to be robust to actions by the large countries. And I repeat, I don't think that name and shame is something that what I have observed inside the EU, a smaller family of more like-minded countries that at the global level, even there, the large countries are not willing to abide by that, sadly.
Thanks a lot, Andre. We've actually got 1 minute. Would the presenters like to make any final remarks or say anything? Yes, Bernard.
Just to reflect a bit on these suggestions. So, Lou, Andre, we're in a bad place. This is not going to happen. I agree, it's not going to happen. Certainly not if we think that everybody's going to be on board. So I think the United States has very clearly signaled they are not in the market for any of this. right? But that doesn't mean the other 163 then have to say, okay, we're not going to consider this. So I think there should be scope for at least working among like-minded countries, which I would imagine are still going to be the majority of WTO members, right? So I think that is really then say, okay, let's just do this. So I think a plurilateral approach might actually be one way of at least piloting, signaling how this might work. The way that what John was suggesting on requiring explanation, encouraging explanation, without, as Alejandro was saying, questioning the legitimacy of what a government is trying to do, is completely consistent with what we are arguing in our book, right? So that's very much the way we also think about an elaboration of a specific trade concern type process, which is not questioning, none of that involves questioning the objective of a particular government. It's all about how you go about doing this.
Okay.
I'll also pick up one thing, what Victor was saying. The way I would suggest thinking about this, and that's why we wrote this thing in this broader perspective of non-economic objectives, of which national security is one element, is to do more on the other margins, except that we're not going to get a whole lot of mileage out of getting countries to discuss national security. I fully agree with what everybody has been saying, but a lot of what governments are doing is not really about national security in that sense. So if we facilitate kind of more action on these other dimensions, where there's clearly much more scope also for cooperation, we might end up in a place where the system actually is being more constructive and helping governments actually achieve what they're trying to do. And I fully agree with Victor. I think the safeguards debacle in the appellate body case law was really a disaster, right? So I think we got a number of those disasters and now we're paying the price.
Thanks a lot. Alan, you got the last word. 30 seconds.
Yeah, the 4 things are needed. One is transparency, which I'd rely on the secretary to a greater extent. Second, setting the agenda. I'd have the director general consulting with others, but setting the agenda for meetings. Third, timeliness. These things, trade measures don't just appear usually without any notice. They're building, you see it, and there should be a discussion of them ahead of time. And lastly, I'd say the WTO's rather terrible record on the pandemic is a case in point. If Victor had been able to get his way, I suspect, he would have had Alejandro Azevedo, have the have the general counsel meet not just once but several times in a row and say, what are you all doing to each other, not for each other but to each other? And so you have to get to a problem up front and be proactive. And does it work? Maybe not, but it's worth a try.
Okay, well, thank you very much for that. And thank you to everybody. This very interesting discussion, including on national security. And with that, unless Lou has anything to say, I think we close down. Till the next time.
Nothing. I just opened the audio so you could hear my dog barking. I have a guardian dog, a German Shepherd. I'm just trying to let you know that we're discussing this. Of course, not enough. We need to do more, and we should make sure that we are barking at the right tree. Thank you very much.
You have a guard dog, huh? Just good to know.
Yeah.
Okay. Thank you very much, everybody. Until next time. Bye-bye.
Bye-bye.